Yes, boy, I'm telling you, in the young thug trial out of Atlanta, Lil Woody was about to take the stand. In fact, he did take the stand, but then he pled the fifth in front of the jury. There are processes and procedures in place. Everybody needs to know if a witness is going to take the fifth, because if you know a witness is taking the fifth, you do not put them on the stand, because once they're on the stand and they say that, it taints the whole trial. And Attorney Steele, the defense attorney for Young Thug, stood up, took the opportunity to make his motion for mistrial. Now we have the judge on the stand ready to rule on that. So let's go back into court.
We ask that the court deny the motion.
All right. I'm going to deny the motion for mistrial, Mr. Steele. At this point in time, I'll note that you've made it, and I'll let Mr. Melnick in just a second make whatever remarks he wants. Do you have anything else you want to say?
Yeah, I would like, but my understanding is, I'm going to proffer this, but that the great investigator who is looking at me, and I trust her, I'd like to call her as a witness. I was told, I was not there, I was told that, and I forget her name, I know her first name, but her last name was and Investigator Long, and I may be wrong, heard Mr. Copeland prior to coming in to the courtroom, almost immediately prior, state, and I'm reading from Mr. Kokomo, if I have to go to jail, then lock me up, and then the Honorable David Box told me, as I was walking in, that he heard, and he's right behind me, so he should be speaking for himself, but he heard Kenneth Copeland tell the prosecution, if I said the wrong people, please correct it, that he's invoking the fifth. That's why I raised it. I'm not saying anybody did anything wrong. I'm saying that if a party knows or has a reason to believe that a witness may invoke the Fifth Amendment in front of a jury, we avoid that at all costs.
But the challenge we're having, Mr. Steele, is I do believe that there's probably been some behavior that probably wouldn't pass the good faith test of there's a lot of influences inside and outside. So I'm going to basically base it on the proffers of counsel and just remind you all of your professional responsibility requirements. Okay.
Well,
so
I'm going to remind it all the time because I live them. I'm just telling the court that in order for you to deny my motion for a this was bad.
And I'm going to deny your motion, and I've made my ruling. So I'm done at this point in time. Okay. In terms of this motion for mistrial.
Well, I'd like to call the witnesses, but I understand what you said.
I'm not going to call any witnesses. I don't need any witnesses. Your proffers are fine. Okay.
Can I add a proffer now?
Yes.
Okay. As you know, we are in a side room off the hallway on the first floor. That's where defense counsel is kind of their conference room. During lunch, I'm working on unrelated matters, and I'm going to get a ginger ale to calm my upset stomach. And I'm on the phone, but I'm hearing a gentleman speak very loudly on the phone with agents from the state. My belief, agents from the state were present within earshot. And that gentleman on the phone, who was Kenneth Copeland, was making a...
How do you know it was on the phone?
Oh, man. Okay, so here's what's going on. You've got this alleged conversation taking place between a number of people prior to Mr. Copeland taking the stand, all saying he's going to take the fifth, he's going to take the fifth. So Steele tries to assure everybody that, hey, if he's going to take the fifth, don't put him on the stand. And they did, and he took the fifth. Bob Mott is here, Katherine Lizardo. Katherine, what the heck's going on here? And did the judge make the right ruling on the motion for mistrial?
Well, the judge has to use the standard of liberally construed when there's a motion for a mistrial regarding the fifth being taken on the stand. Like you mentioned, when a witness takes the fifth on the stand during a criminal trial, it taints the jury, and it may be prejudicial for the defense. But here, the issue is the judge himself asked the witness before the jury was even present, do you want to testify? And he said, yes. So the judge obviously will also allow him to be on the stand and testify. He even said, after the witness said that in open court, okay, we'll bring in the jury and we'll ask you questions. If he really wanted to assert the fifth, he should have reiterated that the moment the judge asked. So Now, the judge ruled that it's not a mistrial.
So, Bob, do you think there was some sort of scheme going on that, hey, we'll make him believe that he's not going to take the fifth, we'll put him up there, he'll take the fifth, and somehow that'll, affect the defense case adversely?
I mean, on behalf of the prosecution?
Yeah.
I don't know. But in terms of these conversations that were going out in the hallway, they're problematic. I mean, kind of flesh out for our audience a little bit, when we're talking about tainting the jury, when you have, and it all relates back to the Confrontation Clause, the Sixth Amendment of the Constitution, as to the defendant, the thought being that if you put somebody on the stand who has entered into an immunity deal, and that is allowing them to testify, and if that person then comes on the stand and takes the fifth, and during the course of the trial, it has become clear that the state's theory of the case is that this person was working in conjunction with or was a co-conspirator with the defendant, then it's a huge deal.
It's a huge deal. And there's so much more to it. And we're going to have to get into it next time. What a heck of a surprise here. Hey, I'm going to thank and excuse Bob Mata and Katherine Lizardo. Always a pleasure. You guys head off. Have a great weekend. We'll see you next time. I'm Michael Bryant. Try to do the right thing. Imran Ansari is up next. Stay where you are. This is Law and Crime.